just a little background of what we're going to cover today is what happens if you pass away without a will or a trust? What are some of the key estate planning documents? How do you create an estate plan? And then I'm going to pass it back over to Nick to talk about how do you prepare your family for that. So I know this chart is very hard to see. We're going to put the slides online, so don't worry. This chart represents what the Florida courts use to determine who gets the inheritance that you leave or anything that you leave if you do not have a will in place. It's called intestacy. And basically, the first question the court asks is, do you have a spouse and do you have children? If you have a spouse, then the court looks to the left-hand side of the chart and says, do you have children? And are those children from that spouse? If the answer is yes, then the spouse gets 100% of your estate. If the answer is no, that the children are from somebody else other than your spouse, is your current spouse would get 50% and your children would get 50%. So it splits it up. And if you are married and don't have children, your spouse just gets 100%. It makes it very easy. If you do not have a spouse, it gets a little bit trickier. So the court asks first is, do you have children? That they wanted to go to the children first. So if you do, the children will get everything in equal shares. If you don't, then they say, are your parents still alive? If the answer is yes, the parents get everything. If the answer is no, is they start looking at your extended family, your brothers and sisters, if you have any. If you don't have any brothers and sisters, it goes a little bit further where I believe it reaches out to your cousins and they'll receive everything in equal shares. So generally, I would say for at least 90% of people, this is not what you want to have happen. You want to dictate how your assets pass on your terms, not on the court's terms. So we just wanted to highlight how do you prevent this situation from happening, because by the time this happens, you can no longer explain, here's what I want, because you're not around to do it. So I'm going to highlight a little bit into the word of what the word says about estate planning. So Galatians 3:15 highlights that exact point I was getting at. It says, brothers and sisters, I'll use an example from human experience. No one ignores or makes additions to a validated will. And that's important because the Florida courts hold that true too. Is if you have a valid will, they're not going to add to it. They may interpret if there's things that are a little bit ambiguous. Verse that I have is Hebrews 9:16 and 17 that says, in the case of a will, it's necessary to prove the death of the one who made it, because a will is only in force when somebody's died. It never takes effect while one who made it is living. And that's true if you have a testamentary will. There's other sorts of wills that I'm going to talk about in a second that they can take effect while you're living. They're called living wills. So I'll talk about that in a little bit. It's a plan for incapacity. So to hit on the testamentary will first, that was what Hebrews 9:16, 17 we're talking about. Is your testamentary will, is your traditional will, is it gets your affairs in order before you pass, and it doesn't take effect until that happens. So what it is, it's a set of instructions. And I'll get into a little bit more detail of what it includes a little bit later on. But it's just that simple. It's here's what I want to happen with my estate. The limitations of a will is it doesn't apply to all of your assets. Is if there's certain assets that you have that are held jointly, like let's say you have a home and it's in, you took possession of that home as a married couple or with a right of survivorship, is your will won't apply to that because that property will pass by operation of law. So you don't need the will to have that property pass in its intended manner because the law already governs that. So with respect to taxes is when you have a will, is everything in that will is subject to estate tax if your estate generally is subject to estate taxes. It's a very, very high threshold. Is if you have a spouse, the threshold is you have to be passing $27 million for it to take effect. So, and that's
That's per child. I hope that everybody in this room will have that at some point. I don't think I ever will, but it's to exemplify that this bar is extremely high. So most people is when they say, oh, you have a estate tax to worry about, is I would say 99.9% of people do not worry about estate tax. So the next limitation, I wouldn't say a limitation of will. The next thing to consider with a will is, even if you have one, your estate goes through the probate process. So it's going to go to that court, the one that we talked about earlier here, but they don't apply their default rules anymore. They apply the rule, what's in your will. So it still goes to that court system. It just, you're not applying their default rules. And I'm not going to call it limited. The thing to think about in that case is, when you have anything that goes to the court system, it becomes public. So whether you intended or not, is your estate will become public, and who it went to will become public. I think there are situations where the courts can redact it. It's just a very uncommon practice. And then just that, the last point about a testamentary will is, it takes effect upon death. Just like the word says, when you're alive, your will it's just a piece of paper, that there's nothing to it. But once you pass away, that will is now an active document. And I'm gonna stop there. I know that was a lot of information very quickly. So does anybody have any questions on just that piece? Sure, go ahead.
Yeah, I've always been told that if you have a will, you can say you don't want it to go through probate. Is that not true?
It is kind of true. You can do it. It depends how big the estate is. That some estates, it's so large that it has to go through probate even with a will. That generally, if you have an estate that's less than $75,000, after your home and things like that are taken out, like the ones that pass by operation of law, those types of estates don't have to go to probate. But if you just requesting that it doesn't go to probate doesn't mean that you can avoid it. Is that fair, Bree?
Yeah, so typically, in a will, you list someone who is your personal representative.
Correct.
The personal representative cannot act without the granting of the powers through a judge. So if your estate is, well, I'll just say it like this. If it's under 75, you still have to go to probate, but it's very simple and very easy. If it's over 75, then you have to go to formal. And in Florida, with everything that's around here, most banks or anybody want that piece of paper from that judge, even if it's less than 75,000. So I've had cases where the estate is less than 75, but because the banks want it, you have to do it.
Thank you. Any more questions on testamentary wills?
How long does the probate take?
Oh, it depends on the court. I would say a few months at a minimum.
And that's even if you have a will.
Even if you have a will, yes. And that's just because of a backlog of cases. That's not that it takes long to go through the proceedings. If you have a will, it's generally pretty straightforward for the court of, you personal representative, you now have the authority to act and carry out this will. That if the court has to figure it out on their own, it takes a lot longer.
So, excuse me, operations of law, you mentioned, right?
Yep.
So if your home is held like joint in tenancy in common?
Tenancy in common, it won't pass by law. It passes, that will go through the probate. If you're holding it as joint tenants with the right of survivorship, that will pass by law. Correct. Yep. But if you have tenants in common, is in effect, it's each one of you owns 50-50, but they're viewed as separate 50s. When you have a joint tenancy with the right of survivorship, is you both own 100%, and you're shortcutting by saying that each one of you owns 50%. So joint tenants with the right of survivorship is when the first person passes away, that the other person takes the full ownership of it.
And to see how your home is held, do the county or you gotta go to a title company?
The clerk's office has that information. It should be, it's on the deed, right, Bree?
I would check your property appraiser's website.
Okay.
So if you're in Collier County appraisers, you can type in your name or your address. You'll be able to see your deed. So you just have to read where it says grantor gives to grantee.
Mm-hmm.
So if it says husband and wife, it'll be considered as joint with rights of survivorship. Or it'll say in tenants in common, or
It'll actually read it out.
you have to read it.
Thank you.
So I'm going to transition into documents that you can put into place while you are alive to account for any incapacity or end of life planning. So the first document that comes to mind is called a living will, but that's also referred to as an advanced medical directive. That they're the same thing. And all that document is, it is instructions to another person saying, if I cannot communicate what I want for my own health, here is what I want. It doesn't grant that person the power to execute it. It just explains to them, here's what I want. So there's another separate document that goes with it. It is a durable power of attorney that allows to give more authority to carry out decisions. I'll get into that in just a second. But the living will is the instructions on, here's what I want. So let's say if you're incapacitated and you don't want to be resuscitated, for example, is you would put that right into your document and say, this is what I want. So whoever is carrying that out knows that and is aware of that. That is the living will. It's a private document. It will not become public information. It is just meant to explain in writing what your desires are if you cannot communicate them in the future. So there's no tax implications to it. There's no really limitations like a will has. It is just this is a set of instructions of what I want for my own health in the future. So it's important to have one of those just in case anything were to happen, and just know that it's a separate document than your will. So before going into those other documents that go with that the healthcare surrogate that is a document that gives the power to another person to act on your behalf. So a power of attorney it truly is this power of attorney. It gives somebody the right to act on your behalf in a financial sense and about legal decisions. A healthcare surrogate is separate. It's strictly related to healthcare. So your healthcare surrogate is a person. It's a form that says, I designate you, Nick, to handle my health decisions if I cannot handle it myself. Here's the advanced medical directive that will tell you what to do, but you now have the power to do it. So that's what that's used for. I'm going to stop there before I go into what goes into a will. Just I know there's a lot to unpack with this one. So any questions?
Yeah, if you have a living will,
Mhm.
is it, and you still have to go through probate with that?
Unless you have a testamentary will. So a living will is strictly for incapacity. It's not for death.
So what is the other one you just said that wouldn't have to go through probate? Testing.
A testamentary will does have, all of these go through probate. Is a living will, it doesn't apply to death. It applies to incapacity. So you're never in probate court in the first place. That it is something that you put in place during your lifetime. And then when you pass, it no longer applies. It's the testamentary will that applies. So these two will types, it's not just pick one or the other. It's you can have both, and to make sure that you're planning for all types of situations.
I'm not checking with this, but so trust doesn't, right?
A trust will avoid probate. Yep, I have that in here. Yep, a trust will avoid probate. I'm going to get to that. Yep, that you'll avoid the process entirely with a trust.
I mean, for myself if I'm not mistaken, for a living will, a good example of using that was, for myself, I had grandfather who got very ill and was able to make decisions for himself on a hospital bed. My grandmother had to make decisions for him, like, do I put a feeding tube? Do I put a trach? Do I do this? We didn't know what his answer was because he didn't give it to us. If I'm mistaken, you can write in that stuff in that living will, so your kids or your grandkids don't have to make those decisions for you. This is what they wanted, right?
That's exactly spot on.
So that's where I would have loved to have that in place before that scenario happened, right? Because I don't know who wants their kids to make a decision for you when it's like a life or death scenario, right?
So then we have to deal with the.
Right, exactly.
Yep.
Exactly. Yep. Exactly.
So I just wanted to highlight, this is the last little section I have about wills, is what do they typically include? And I use the word to kind of highlight what they can include. So I'm going to start with 1 Chronicles 22:5. It says, "For David said, Solomon, my son is young and inexperienced, and the house that is to be built for the Lord must be exceedingly magnificent, of fame and glory throughout the lands. I will therefore make preparation for it." So David provided materials in great quantity before his death. So in this verse, what we see is he identifies a beneficiary in Solomon. Solomon's going to be the one who receives these materials. He identifies the assets that he's going to be transferring, the materials themselves, and he gives some sort of instructions on what to do. It's not much in here, but there's something. And then in 1 Chronicles 22:17, David ordered the leaders of Israel to help his son Solomon. So in that, he's saying, hey, leaders of Israel, I need you to execute this will in furthering what I'm leaving to Solomon. And then lastly, in 1 Kings 2:10, it says, "Then David rested with his ancestors and was buried in the city of David." There's not much involved with this, but it's what I took from it is it accounted a little bit for his funeral arrangements. He didn't say it directly, but it ties in, is you can put your funeral arrangements into your will of here's what I want. So in Florida, what we see as common will provisions is the list of assets, what's going to be passed, the beneficiaries, who's going to receive them, the executor is who's going to be the one to transfer all of that, the funeral arrangements, guardians, if you have minor children, is who do you want to look out for them and be responsible for them. Is in Florida, there's actually some people who have guardians for their pets, also common. And then the last thing is personal information, is who are you? So that way when it goes to the court system, it just doesn't get slowed down. They know exactly whose will this is. So that's all I had on wills. I'm going to jump over to trusts unless there's any more questions on the wills. Perfect. So this is switching gears entirely into trusts. And as we mentioned before, trusts, the benefit of trusts is that they avoid the probate process. The reason why they avoid the probate process is because they're treated as separate legal people. So when you pass away, is all of your assets that goes through the probate process because you are no longer there to oversee and control those assets. So the court has to figure out where do they go. If the assets are in a trust, that trust didn't pass away. You as an individual did, but the trust did not. So the trust will continue and does not go through the probate process. So the terms of the trust can pass the property in the same way that a will passes property. So just as a really quick summary, it's a separate legal entity that holds assets. And when you pass, it passes those assets in the way that you wanted them to be passed. So there's a lot of limitations and formalities associated with trusts, especially in Florida. That Florida is one of the hardest states, most complicated states to set up a trust, just because there are formal requirements of it has to be funded with something right off the start. There's signing requirements of you need multiple witnesses to watch you sign this trust. It needs to be notarized. That your trustee, the person who is overseeing those assets, if you only have one trustee, it can't be the same person as your beneficiary. So if you wanted to leave something to an only child and you put the assets into a trust, is that same child can't be the trustee during your lifetime. So there's a lot of formal requirements that Florida has that other states may not have. So it's important, just if you're going to put a trust in place, is to make sure you do it the right way and just comply with those formalities, because without them, you don't have a valid trust. And people who have trusts generally don't make a will. And if you don't have a will, you go through the court probate process. So it takes you from having what you think is a great trust that's not going to go through probate to being subject to the default rules of the court.
So you have to have a will with a trust.
You can have a will with a trust. You don't. You should. You don't. Yes, you don't 100% need one, but you definitely should have one. So that's the other thing. So unlike a will that only takes effect upon death, a trust is effective immediately. So what that means is that your trust, it's a separate legal person. It does its own tax return. It does its own. It's basically, you are creating a new you. I don't like the analogy, but it's you. You are now responsible for your own tax return and your trust tax return. Your trust has its own bank account, so you're going to have an extra bank account to consider. So it's almost running two separate legal persons.
So you got to feed the trust, right?
Yep. Yep. So
You're opening the bank account and adding your assets.
Exactly.
What are you adding the funds to the trust for? For your taxes, your insurance?
So right off the start is you have to fund the trust with something. Otherwise, it's not a valid trust. So you don't need to do a lot. So historically, what attorneys used to do is tape a $10 bill to the back of the trust document. So there's no question that it was a funded trust. In having your assets grow in the trust is you don't need to fund it every year. That you can do that on you can have your assets grow in the individual capacity, but if you have a trust, it makes sense to fund the trust, because how people set it up is they say, I'm going to establish this trust. It's for my benefit until I pass away. And then the beneficiary becomes whoever you want to pass to. And because you're the beneficiary during your lifetime, you can move money in and out of that trust like that. Not all trusts are like that, and it's very, very nuanced of what you can do for each trust type. I'll get into the different types of trusts on the next screen, but you need to know what type of trust you're setting up to figure out what you can do with it.
One quick question. So by putting your primary residence in the trust, you're already funding it, right?
Yes.
Funding it.
Yes, that's funding it. Yep. But then when the property assessor comes and says, hey, I'm going to give you your property tax bill, it doesn't go to your name anymore. It will go to the trust name. Yeah. So the trust will be responsible for paying it. You can put money into the trust to pay it. It's just that the bill will be in your trust name. Yeah, go ahead.
So do you have to get a federal identification number for the trust, or is it your social security number associated?
I think you can get one. I don't know if you need one.
You would just use your social, I guess?
Yeah, on its tax return, you can put either the beneficiary's social or the trust's federal ID number. Is the getting the ID number is actually really easy. It takes 5 minutes.
Is it beneficial to do so, or is there a reason why you would?
The reason why you would is it makes it a clear delineation of this trust is not me, and it kind of highlights that. And it's
Also, when you make accounts.
when you make a bank account, it helps to give them a federal identification number rather than your social.
Bank account, investment accounts, anything like that. So you definitely want to have the number at hand, absolutely.
All right, so just building on what we had is there's different types of trusts. They all have different purposes. If you have specific questions on these, Bree is your person. I can just give you a high-level overview. I can't tell you everything about all of these trust types. It's because I'm a tax person. If you ask me what are the tax implications of these, I can tell you spot on. But if you ask me what are these trust types, how do they work, I'm not the one. I can just give you an overview of what they are. So A revocable trust is just that. It is a trust you put in place that can be changed at any time for any reason. It's easily interchangeable. The limitation of a revocable trust is that it is not treated as a separate person from you. The reason why is because you can change it at any time. So the law doesn't see a difference between the two. When you pass away, a revocable trust becomes irrevocable, meaning that it won't go through probate. But while you are alive, if you have creditors or any sort of outstanding debts, and those creditors can reach the assets in a revocable trust. So exactly. So the protections that you think you have over the assets in a revocable trust aren't really there. It's just an extension of you as a person. So it's a common trust if you want to change it and you don't have creditors to worry about or nothing really to worry about. It's just I want to have it just to have it. That it's a useful tool because you're going to avoid probate later. Irrevocable trust. This is the most common type of trust. This is what people think of like your standard trust document. It is an irrevocable trust. What that means is you generally can't change it. Is once you set the terms, they're set. Is the irrevocable trust, think of it like a will. It is set in stone, signed, sealed. These are the instructions on how things passed. The beauty of an irrevocable trust is because it's a separate person, your debts, if you have any, are not its debts. And its debts are not your debts. That they're separate legal entities. And the irrevocable trust, it acts like a will also, in that it does not go through probate, but explains, here's how I want my assets to pass. The limitation of an irrevocable trust is you can't change its terms. So once you write it, it's written, which is why there's intentionally defective trusts. Intentionally defective trusts, they're the same thing as irrevocable trusts. They are once they're in place, they're in place. It doesn't go through the probate process. But the attorneys who draft these make it intentionally defective so that way you can change it. So if you ever have to have terms that change, that's what you use. Florida, this name gets such a bad connotation of intentionally defective trusts because people think if you are intentionally doing something wrong, you're trying to avoid some sort of consequence from happening. That's not the case here. What the intentionally defective trust does is it gives both asset protection and control of those assets to the person who funded the trust. In your first two trust types, the revocable and the irrevocable, is you don't have that control over the assets in your own power. There is some level of control, but it's not complete control. You can't just move things around and change things. With the intentionally defective one, it gives you both the assets in your control, but also that creditor protection. So it has the benefits of both an irrevocable and irrevocable trust. The next one is charitable trusts. And that one is very simple. It's used for charitable giving. That's all it's for. It's generally for people who are subject to estate taxes, which again, really, really high threshold. So it's uncommon for most people. The reason why they're used is it lets you accelerate charitable deductions. So you can get a lifetime's worth of deductions all in the first year. So if the money is to go to charity, it can give you 20, 30 years of deductions all at once. So that's the benefit there. The next one is Medicaid Asset Protection Trusts. Is this one? So I'm not a Medicaid expert, but Medicaid has income limits and asset limits. And if you exceed either one of those, you don't qualify for the programs. What a Medicaid Asset Protection Trust does is it takes your assets and puts them into a separate trust. So you're now below the asset limit. If you're then also below the income limit, you qualify for Medicaid. So what the purpose of this trust is to help you become eligible for Medicaid without spending your assets that you own currently. Is it just moves them to a separate legal entity. You can receive income from it on a go forward, but the reason why this works in Florida is there's some Medicaid rules that say in other states there's Medicaid rules that say we're going to look at other trusts you own and are able to take some sort of payment back. Florida doesn't have that rule. So if you have a Medicaid asset protection trust, is all of those assets that you moved into it don't have to be paid back to Medicaid later.
May I ask, does it have a look back period? Usually they say it has a
5-year look back period. So is if you can avoid that in the first place, you set it up 5 years before you apply for Medicaid, best possible answer. If you do it today and apply for Medicaid tomorrow, it still counts. And that's what the weird rule is in Florida, is that, so the 5-year look back, it's whether you have to pay Medicaid back after the fact. And because because Medicaid can only take from your probate estate in Florida, is those assets, because they're in a trust, aren't in your probate estate. So you wouldn't pay those back. So it's an interesting little rule that Florida has that other states. Yeah. So there's a lot of benefits to those. The only thing that I caution on this, they're extremely complicated. They're extremely nuanced. I would recommend going to a pro. I don't know if Bree does those. She does not do those. I know who does if they're needed. That there's a person who I've worked with in the past who's up in either Fort Myers or Cape Coral, and she's been doing them for 30 years. So she knows what she's doing, and I can get you contact information if needed. Yep. And then the last one is a special needs trust. So it's kind of like a Medicaid asset protection trust. It's made if you have family members with special needs. And all this does is it gives them the funding that they need to for their care, support, maintenance, and also keeps them eligible for government programs. Those programs have rules in place that says if you receive funding from a trust, you're no longer eligible for this program. These trusts are set up where you can receive funding, but you keep your eligibility. So it also is a little bit detailed in the same way the Medicaid asset protection trusts are, but it's made for people who have family with special needs. So the last thing that I want to just kind of touch on really quick is how do you create an estate plan? Is my recommendation, it's not because I'm an attorney and I'm biased, it's because it's complicated, is have an attorney do it. The cost for a will is you're looking anywhere between $200 and $800. Depends on how complex things are and the size of the estate. The cost of a trust is anywhere between $750 and $3,000. It depends what the needs are, how much time has to go into it, but trusts are typically a little bit more expensive because they have a lot more benefits and they avoid the probate process. There's a lot of formalities that have to be followed in that. So that's the first option. Second option is do an online version yourself. Is the cost of a will online is $200 a person, and then they have an annual maintenance fee just to keep it online between $25 and $50. So people think, hey, I'm saving money by not going to an attorney. You're really not. You're probably going to spend more if you plan on living for more than 8 or 9 years. So they kind of get you. They get their fees too. That they have attorneys put it together and they get paid. Is with respect to trusts, is I would highly advise against doing a trust yourself. Reason why is there are so many formalities that have to be followed that you may mess it up, and if you mess it up, it takes you to the position of not even having a will. So Florida courts will apply their default rules, and you end up in the worst possible situation. So what I tell people is compare it to the cost of probate court. Is probate court, if you have an estate less than $100,000, the total costs of probate are going to be between $1,500 and $3,000 total. That's attorney's fees, accountant's fees, court fees, everything included. if you have an estate between 100,000 and a million, it's 3% of the estate. So if let's say you have 999,999, that's $30,000 of probate costs. Yeah. Yes. And then anything over a million is you're talking 1 to 2% of the estate value. So still very high dollars. That I actually found this online, which it's a little skewed just with a lot of wealth being in Florida, but the average probate cost in Florida is $30,000. That I think a lot of that has to do with the large estates that get passed, but it's not something cheap. So if you can avoid it in the first place, it's a great idea to do that. So I want to boil it down to just 3 key takeaways: is don't let the courts decide how your property passes. Put a plan in place. Second one, plan for incapacity. Nobody wants to go through that, but if you're planned for it and your family knows, here's what my plans are, it makes their lives so much easier, and there's far less guilt associated with any decisions. It says, here's what I want, please just carry this out. And it also helps them manage your legal, financial, any sort of your other affairs. And then last thing that Nick is going to talk on is prepare your family for that. So that's all I had. Does anybody have any questions before I pass it over to Nick? Yeah. All good.
So whether you do a will or a trust or perhaps both,
Mm-hmm.
you really need to go to an attorney to have that done. And what makes it authentic?
So for a will is you can do it yourself. I'm not advising against that. Is you absolutely can do that yourself. There's formalities that have to be followed when you sign a will. Is you have to have two people witness your signature, and they need to witness each other's signature. That it's a best practice to get it notarized. Can you you need a notary on a will?
But then you don't have to file it, like, no,
Nope.
you just put it in your.
Put it in the drawer. Yep. Yep.
And then the trust, though, really.
The trust, there are so many formalities that have to be followed that it's just worthwhile to talk to an attorney. That if you tried to do it and you mess it up, that's a very, very costly mistake. Just I'm not saying it because I'm biased. I'm saying it because it is a fact of if you mess that up, that it will cause the courts to say you didn't have a trust, you didn't have a will. We need to apply our default rules.
Yeah.
So
Avoid that.
yeah.
Nobody likes a default.
So thank you, everybody. I'm gonna pass it over to Nick. And
Thank you, Brian. You're good, bro. Really good. Wow. I'm telling you, every time I hang out with these people, I learn more and more every day. I mean, it's just a blessing to be around people like Brian, people like Bree, that God has given them the time and the knowledge and even the willpower to even learn these complicated topics. I mean, just 6 different trusts alone, way over my head, right? It's a lot of stuff. That's why it's awesome to even have someone like Bree to sit down with if you want to review your trust, or you are in the idea of maybe making a trust yourself. Sit with her, talk with her, figure out to see exactly what type of trust, what you should be looking over, why you should even have a trust if you need it. So she'll be after for all of your questions, but also to get in contact after this class as well. But what I'm going over, I'm not going to go over too much. We learned a lot today. So very simple stuff when it comes to inheritance planning. In scripture, it tells us, right, that a good person leaves an inheritance for their children's children, right? We always hear about this. How can I save enough money for my kids or for my grandkids? But nobody navigates us to do that, and how to then teach our next generation who then receives said trust and inheritance what to do with those funds. What do I do with this inheritance? Do I just go and just buy a new suit? Do I just go on vacation? What do I do with this? And what David did, he instructed Solomon with that trust and will exactly what the next steps are to use said materials and said inheritance to then further his own kingdom. So I want to go over actually some mistakes or common mistakes that happen with a large sum of money that comes to us all of a sudden, right? The very first thing I see a lot is unnecessary spending, right? We're going out to the mall. We're like, oh my gosh, now I can go buy my Louis Vuitton purse. I can go buy my new shoes. I can go get a new TV, or I can go upgrade my car, get a new stereo, right? It's like, oh my gosh, now I got a lot of money. Let me go throw it out. Or, oh my gosh, mom gave me a bunch of money for inheritance. I'm going to go to Dubai now. Or I'm going to go out of the country for my once in a lifetime vacation and just spend 10 grand on tickets and go stay at the nicest hotels, right? Or we look at not creating a plan, right? Not doing a trust or will at all. Just saying, I can handle it. You know what? Mom and dad, they gave me this information, but you know what? I'm just going to keep it in one place and do whatever I want with it because I know best, right? And people say that if you don't listen to your elders, and if you don't know your history, you're bound to repeat it, right? So if you are wise to listen to your elders and the people who are giving you instructions, you are bound to a better future. Number 4, non-stewarded giving, right? What does that mean? When people find out that you've received a large inheritance or made a lot of money, everybody's your best friend. Everybody wants to grab that $5. You know what? I got this $1,000 credit card balance and I need to get rid of it. Can you help me out? Right? Usually that happens. We know the story of the prodigal son. When he asked his father for his inheritance, he went into the market and he spent his money and everybody was his friend. He was spending on girls and food and drinks. And then he lost it all. And then he was down eating food that the pigs were eating. And he had to go back to his friends. Hey, dad, you know what? I just spent all the money you gave me for inheritance. I'm sorry. Good news that dad took him back and helped him with it. But if we can teach our generations to avoid that and not stay in a place where you're eating with the pigs, right? That would be wise, right? And the next thing is making permanent decisions. A lot of people, when they see a large amount of money, like now I can finally get a down payment on a house. But they never looked at the cost of the house. They never looked at the taxes or the insurance or what they should do. Or other people receive a large fund of money. They say, now I can quit my job. I've made a lot of money. I'm going to now work for 2 years and go back, right? Don't make those quick decisions. So teaching this to our generation who receives our inheritance will help navigate them to avoid these mistakes. So what are 3 good recommendations to give to our kids and grandkids? Well, number 1, let's protect them. Let's give them knowledge to protect themselves. Let's make an emergency fund. At least minimum 3 months of their monthly income, so that if a God forbid moment does happen, they're not running to their credit card. They're not running to debt. They're not asking for another personal loan. If their car breaks down or their AC is stopped working, they can go to their emergency fund and use it for themselves, right? Number 2, getting rid of their consumer debt. Their credit cards. Right now, we're looking at credit cards that are touching 18%, 20%, 22%. I'll tell you right now, there is not an investment. As a broker, there is not an investment right now that's averaging a 20% year over year growth to say that I will just put all my money in an investment and avoid my consumer debt. It is wiser to get rid of said consumer debt so then you can invest the rest, right? And then number 3, let them know, look, I gave you that inheritance. It would be wise to put a portion aside for your own retirement. So you can create that generational mindset that you can now not only fund your kids' retirement, but now they're thinking about their kids' retirement, that I now have something myself to give to them. Now, there's a lot of misconceptions when it comes to credit cards and debt. So my next slide is actually going to go over a little more mathematically of how much that interest looks at 18%. So let's say you have a credit card for $3,000. That's how much is on your credit card. And you're only paying the minimum amount every single month. It would take you about 10 years to pay it off, and you would be paying an extra $2,000. So something you borrowed for $3,000, you're totally paying back around $5,000. Would it not be wiser to educate our next generation, hey, look, get out of your consumer debt so you can avoid that $2,000, that extra interest payment, right? The next thing I want to go over is bringing peace of mind to the people who don't have such a big inheritance to give to their kids. It's not that you have to give them $100,000, $1 million, $2 million as an inheritance of, oh my gosh, I have to reach this amount to make sure I gave enough money for my kids. No, the good news is if you teach them compound interest or the rule of 72, look, with just $10,000 allocated in the right places, you can retire them correctly, right? So if we look at the first one at 3%, those are usually CDs, high yield savings, maybe a money market, right? If you put in at $10,000, it takes about 24 years to double, right? 10,000 would be 20,000. If you go to 6%, that's like over the years of maybe like an index fund or a better bond account or something along those lines, or bond fund. You're doubling the 10,000 every 12 years. But then if you're going into a place, let's say managed accounts or into other types of mutual funds, or having an advisor walking through SEMPs, you could potentially be touching 12% every year. In 48 years, that 10,000 you gave as inheritance can be $2.5 million from just $10,000. Now, am I saying that there's an investment out there that will compound every single year at 12%? No, because I would be lying. Markets go up and down. It is like a basketball. I tell most people that you bounce a basketball up a flight of stairs, right? Over 100 years, market still goes up. As you see, gas prices, it's never going back to 10 cents for gas, right? Never. It might go back down, but it won't go back to 10 cents a gallon. That just shows you how markets do end up going up, but you have that bouncing fluctuation. But by teaching your generation about compound interest, that look, mom and dad just gave you this amount of money, save some for a God forbid moment, your rainy day, put some away that will take away your consumer debt, and look, put now another section into your own retirement. You can compound that to much higher degrees than just keeping it in your savings account or just putting it somewhere else. So that's where I wanted to end off here. This very last 3 steps again is that emergency account, getting rid of your consumer debt, and then putting money aside in a wealth building account or their own retirement account to then prepare your next generation. Do you have any questions for myself on those last slides? Because I didn't want to go into too much detail. We learned so much today about trust and wills, phenomenal. But any questions on those previous slides?
Well, let's talk about that consumer debt, right?
Yes.
So you have multiple credit cards and you want to pay them off.
Yes.
You suggest you just start with the smallest one and pay that one off, and then.
Right. So you have that, but Chelsea just said snowball effect. Absolutely. So if they receive that large inheritance for themselves, let's say you're passing on a large amount of money to your kids and they're able to pay off completely to zero all of their cards, wipe it clean. Because now they have more money monthly, right? Instead of paying those minimum payments of $100-something a month, they can put that to their own investments or savings, etc. That will end up compounding, as you saw, with just 10,000 to 2.5 million in 48 years. But if they have their own debt, let's say, I don't know how to pay this off sooner, there are tools out there. I mean, myself, I make what is called a financial needs analysis that actually walks people through their debt resolutions. I also teach people how to pay off their houses faster. You can put in your credit cards and it looks at exactly the balance and the percentage. And then it tells you which credit card you should be attacking first and how to pay off sooner. So there are those moments, but that snowball effect is the correct method of how it works. Once you pay off one credit card, you take that same balance you were paying every month to pay it off to the next balance, and then that amount to the next balance until that snowball gets bigger and bigger. Then you can add it to said mortgage. But if there's ever an idea of like, okay, well, which of the 5 or 10 or 13 credit cards do I start at first? You can always contact me later and I can actually walk you through that plan, give you a paper step-by-step of how to complete that to get you out of debt. Me and Brian, we believe that debt right now in America is modern slavery. Scripture says that if you're indebted to anyone, you are now their slave. Very simple, very black and white. Why? Now you are under their shoe, their chain, where it's like, I have to pay this, otherwise they take my stuff away. If that's not slavery to me, I don't know what is. And in America, there's this debt culture. We love our credit cards. That plastic card is our best friend. The moment it's at 0, I can get Jordans. The moment it's at 0, I can get a new purse. Woo! Yes. But teaching that credit card culture out of the next generation after us will help them at a better future, right? What are the right debts? Like mortgages, stuff like that. We'll have other classes talking about good debt and right types of debt. But simply today is getting rid of consumer debt. Credit cards are bad. But for this last slide here, we actually have this QR code here on the screen. If you guys would like to scan it, it's basically like a questionnaire of like, is there any other topics you'd like us to speak next time? How did we do? Is there any stuff that you would like us to improve on? We would love your feedback just to improve what we're doing. And then also all of our information is here on screen to get in contact with me. Myself, I am a licensed broker, so I do investments, retirement planning, but I'm also a licensed life insurance agent to help with family foundation and structure to navigate your protection. Then we have Mr. Brian, who does taxes, and he's a tax attorney. If there's any questions, if you are 1099, how to navigate those, he's the one to call, or business taxes as well. He's a genius around that. Then we have the amazing Brianna, who is called here today to help you with trust and wills, to navigate you through those steps. And if there's anybody that you know that needs help with any of these topics we talked to, send them to us. We are just excited just to spread this knowledge. Awesome. Otherwise, thank you guys so much for coming.